political, there is always room for us to be in conflicts at every point in our life. No two individuals are the same, like I earlier mentioned. So, of course, there is bound to be conflicts. There are different stages of conflicts. The first stage is the latent stage. I don't know whether, okay, yeah. So the first stage is the latent stage. At this stage of the latent stage is the stage that the actions that must have caused the conflict is being done. At this stage, we may not know that a conflict is happening. Let's say, for example, in a company, let's say an employee imputes a wrong figure in maybe a report that is to be sent out. That action itself is bound to cause conflict in the future. But at that stage, the manager or the employee may not know that a conflict is bound to happen in the future. So it's a latent stage. Nobody knows at that point. At the perceived stage, which is the next stage, this is the stage when this error is now being known by everybody. At that stage, the issues that may erupt from this error is now known by everybody, and at that stage, that's when the manager will have to call the employee to come and explain what caused that error in the first place. Then at the third stage is the felt stage. This is the stage where the workers feel anxious. They feel anxious over what they might have done that may have necessitated So at the first stage is the stage that whatever actions they are done are being felt by the worker, is being felt by the manager, and at that stage a conflict is bound to happen. So this discussion today, we will try and see when at this stage is best to manage conflicts in our environment and in our workplaces. The next stage after the felt stage is the manifest stage. It's at this stage that the actions that may escalate the conflicts are carried out. Now, when somebody maybe does something that is quite bad in our workplaces, even in our homes, maybe the children, they might have done something that you gave them an instruction and they didn't carry it out, we tend to get angry. And it's at this stage that we are the manifest stage. We manifest our angers towards our children, towards our employees in the society, and towards people that we normally communicate with every day in the society. So at this stage, the manifest stage, this is one of the most important stages when we are trying to manage conflicts. Because at this stage, this is the stage where what we say or what we do may escalate or de-escalate any conflicts that we find ourselves in. So the aftermath stage is when we have maybe talked about the conflict, we've tried in our own way to resolve it, and at that stage we know what to do or how to go about resolving the conflict. So generally there are 4 types of conflict. The next slide please. There are 4 types of conflict. There is the intrapersonal conflict. The intrapersonal conflict is the conflict we usually have within ourselves. It's within our mind. We maybe choices we want to make. We want to buy something. Or as lawyers, maybe you feel that this decision you're about to take may not be the best, but maybe you will say, oh, there's so much to benefit from it. So those kind of, should I do it, should I not do it? These are types of intrapersonal conflicts. Interpersonal conflicts are conflicts we have with our neighbors, with our employees. Those are the type of conflicts that come under interpersonal conflicts. Intra-group conflicts are maybe I have conflicts with my colleagues, within that group. Those are what we refer to intra-group conflicts. The inter-communities clashes we have between different communities, they are fighting over ownership of boundary lands and the rest. So those are the type of conflicts we usually have. So to the crux of the matter, What is conflict management? Conflict management is the practice of being able to identify and handle conflicts in a sensible, fair, and efficient manner. Please, let's take cognizance of the three words that have been used to describe what conflict management is. First of all, it must be in a sensible manner. It must be fair and it must be efficient. So, if, for example, you are in the place of authority to try and see how you can resolve conflicts between people, you have to be fair, first of all, and you have to ensure that you resolve it in an efficient manner and also in a sensible manner. It can also be referred to as the process of dealing with expected incompatibilities or disagreements arising from diverging opinions, objectives, and needs in our workplaces. So what are the orientations or outcomes of conflict management? There are three orientations of conflict management. If we are managing conflicts in a proper way, it's either you come out with a lose-lose outcome, a win-lose outcome, or a win-win outcome. In the first, a lose-lose outcome, it's an outcome that everybody that is involved in the conflict comes out as losers. These are the type of conflicts that we see maybe during ethnic crisis, political crisis, and crisis generally that goes beyond personal crisis within ourselves. Let's say, for example, there's a crisis between land boundaries and all of that in our communities. They end up killing each other, destruction of properties and all of that. So they all come out as losers. In a win-lose outcome has to be when, let's say, for example, like distinguished peace advocate has said now, he went to court. And at the same time, there was a winner and there was a loser. He came as a loser, and the other person came out of that case as a winner. So that's what that involves. For the win-win outcome, this is an outcome that is usually preached by us at the multi-door courthouse. It involves everybody trying to see how they can let go of some aspects of what they believe is theirs, so that at the end of the day, everybody comes out as winners in that conflict resolution. So the win-win is always what we aim to achieve when we try to resolve conflicts amicably between people in our society. So next, we shall be talking about the conflict management styles. Generally, there are 5 types of conflict management styles that we can use to resolve conflicts wherever we find ourselves. We have the collaborating, we have the competing, we have the avoiding, the accommodating, and the compromising. Collaborating style, which of course is what we preach every day, has to do with the parties coming together to collaborate, trying to discuss over the issues that are, causing the conflict in wherever they find themselves. When they discuss over such issues, they can reach a compromise and say, oh, okay, let's do it this way or let's do it that other way. So that is usually the best way of going about it. But for the competing, we're talking about a situation in which there's a person that is usually in charge, maybe a boss, maybe as fathers in our house, and you impose what you feel may be the best way to resolve that dispute. That is what competing is talking about. So maybe as peace advocates, you find yourself in a situation where you need to resolve something as quickly as possible. You have the authority to do that. You simply just say, oh, let's do it this way or let's do it this way so that this conflict can be resolved. You usually don't have the time to discuss and collaborate to see whether there is a peaceful way of resolving the dispute. So the next is the avoiding stage. By avoiding, or the avoiding style, by avoiding, what we mean is that you try to avoid the conflicts. There are some conflicts that you may say, oh, let's keep this aside, for a later time. You know, that's what the avoiding system is talking about. By accommodating, we are trying to say that we should accommodate what the next person is preferring as a solution. It's more or less like, oh, let him win so that there will be peace. You know, you accommodate what he's trying to say and say, okay, since you are suggesting that this should go in this manner, okay, let it be like that so that there will be peace. And lastly, the compromising. The compromising is more or less finding a middle ground. Finding a middle ground in trying to resolve the conflict. It involves letting each side know that let us see what we can let go towards resolving the dispute. At the multi-docket house, we do that a lot when trying to mediate with parties. We tell them that, oh, you feel that you are entitled to 10. Why don't you let go of 2? Let the other party let go of 2. And let's see how we can reach a middle ground in resolving or managing that dispute. So those are normally the types of styles most people can adopt in trying to resolve conflicts. So there are some best practices and skills we as peace advocates can imbibe in resolving disputes in wherever we find ourselves. You know, that's what we'll be discussing. On top of that list is effective communication skill. Very important for us to understand what is causing the conflict. You have to be able to communicate effectively. It's of utmost importance in managing and preventing and even resolving conflicts in our society. Effective communication skill is the process of exchanging ideas, thoughts, opinions, knowledge and data so that the message is received and understood with clarity and purpose. When we communicate effectively, both the sender and the receiver feel satisfied. So if we are not being able to communicate with conflicting parties, they may not feel satisfied. They may not even understand that we really hear them and know that this is where they are coming from. So it's very important that we communicate effectively in places that we find ourselves trying to resolve disputes. It's a very important skill. So for us to be effective communicators while trying to manage conflicts, we have to be clear, we have to be correct, we have to be complete, concise, and compassionate. As peace advocates and conflict management, we must imbibe these effective communication skills. We must pay attention to our speech and the way we speak, and this may be a determinant as to whether a conflict is managed, resolved, or escalated. When you find yourself trying to resolve a conflict or manage a conflict, a warm smile does a lot of tricks. You know, speaking from experience now, when you meet conflicting parties, when you start the meeting with a smile, they always feel at ease and they will be willing to open up to you for you to look for a common ground of resolving the disputes. Another good skill that we should try and imbibe is good listening skills. Listening skills involves us hearing what the person is saying. As much as possible, we should also try as much as possible to inculcate listening to what the person is saying, and so that we can in turn pass the message to somebody else if we are trying to manage conflicts in our society. Another thing we should be aware of is conflicts. Be aware of conflicts in anywhere we find ourselves. I think a lot of people, they've talked about that today. Be aware of conflicts in our workplaces, in our companies, in our society. Have an eye for knowing where conflict is about to start, and try and see how we can help in resolving that conflict. So we take a considerate and rational approach to conflicts. We should try as much as possible to appear to be neutral when we are trying to resolve conflicts, We should avoid making use of statements that may make one person feel that we are taking sides in trying to resolve the conflict. Then we should always investigate the situation. Wherever we find ourselves trying to resolve disputes as peace advocates, don't just rely on whatever the parties there are telling you are the facts. Resolve or investigate rather the situation. Investigate what may have contributed to that conflict before we see how we can resolve the conflict. Then of course you have to decide how to tackle the conflict. Like I earlier mentioned, there are four different styles of resolving conflict. You know whether you have to tell the parties to collaborate, or you know whether you have to avoid that conflict, or you know whether you are to tell the parties to compromise. But the only way you can do this is if you investigate what is the source of the conflict, and that is when you'll be able to take an action. Then of course you should let everybody have their say. One of the reasons why most conflicts are not resolved is the fact that one set of the parties feel that they are not being heard. We've seen this over time, you know. I think that can even be replicated towards what we are seeing now in Russia and Ukraine. Russia feel that they are not being heard of what their concerns really are, you know. So when we are trying to resolve conflicts, make sure that everybody is heard. Let them feel that they are being heard, and that will assist us in resolving disputes. So you also identify the options and agree on the way forward. Like I earlier said, when you've heard everybody, you can now decide what actions to take. And of course, when you've reached a resolution of the dispute, you have to implement what is being agreed. So what are the advantages of conflict management? In our workplaces, there's a need for us to manage conflicts effectively, because there is no way we can have a peaceful workplace if our employees are always fighting with each other. And in turn, when we resolve and manage conflict peacefully in our workplaces, we see that there is increased productivity. You see people that are at ease. They tend to work in harmony. They tend to produce more in our workplaces. So we should always try and encourage resolving disputes amicably in our workplaces. But what about in our personal lives? Conflict management also plays an important role in our personal lives and society. Tussles and fights spoils relationship and only increase our list of enemies. Everyone needs friends who will stand by us when we need them. Conflict must be managed at homes as it spoils the ambience and spreads negativity. Charity begins at home. If we can effectively manage conflicts in our home, we will see that our families can go out there and spread the goodwill to others in the society. We manage conflicts in our everyday life. If there is to be global peace, security, and stability in our society, there is the need to manage conflict in a way that it will be beneficial to all of us. It is time to make conflicts constructive rather than destructive. It is time to make it overt rather than covert. It is time to make it marginal rather than fundamental. And it is time to make it peripheral rather than pivotal. Charity indeed begins at home. And if we are able to effectively manage conflicts in our homes, organizations, places of business, and society, it is my strong belief that same will transcend to us achieving global peace. Thank you for listening, and God bless.
Thank you very much, sir. What a wonderful presentation. Please, our caterers, can you please serve in silence so that we can enjoy ourselves here in peace? Thank you very much. Let's applaud him one more time for that amazing presentation. Thank you so very much, sir, for doing justice to this work. Like I told you, we are receiving 3 papers in succession, rapid succession. All three of, can you please help us talk to the caterers? Caterers, please, serve in peace. Serve in peace. We cannot have conflict in our kitchen. And we have a peace conference.
A brief one to all our peace advocates here. The essence why we are gathered patiently is basically on what our resource persons on conflict resolutions have to say. The reasons why we have taken all the pain to organize this event is what we are seeing now. So I really need that we pay rapt attention. Even if we are eating, our ear, our brain, everything should also be with what they are saying. Whatever questions you have to ask, please get set. I think they are in a better position to give answers. So that's just what I want to say, that we should all pay close attention. Thank you very much.
Thank you very much, sir, for that ad-lib. We appreciate that. As a matter of fact, I even began to understand the importance of these people presenting to us now when I got to know where they are coming from.
I think I would suggest the food to be served should be prepared in a takeaway bag, because you cannot be eating and listening at the same time. And you find out now that there's conflict in the kitchen because of something like that. Please consider this and let us have peace.
Okay, thank you very much. Wonderful suggestion, but it's coming a little late because of our eating already. And if you say some others will not eat now, you are looking for equal right. Equal right. You hear that we have some members of Committee of Defense of Human Rights in this place. My right. So please help next time or for tomorrow, we'll put this suggestion to work. But please, let's eat in quiet, and kitchen people, please serve in decorum. You are serving World Peace Advocates. Don't quarrel over our food. Thank you very much. So the papers we are receiving now is being presented by members. It's important I say this so that you know those that are talking to you and the authority on which they are speaking. They are not speaking from hearsay. They are not armchair practitioners of what they are talking about. I just needed to get clarity. The people speaking to us, they are all members. 3 of them, their DG was here earlier and he spoke. They are all members of Delta State Multi-Door Courthouse. Delta State Multi-Door Courthouse is an alternative dispute resolution organization. The ADRO we have been talking about, that some lawyers are writing exams to be a part of. These people are already part of it. Am I correct? So they are practitioners of alternative dispute resolution, which we, as World Peace Advocates, we are armchair. We are close to them. We are not them in reality. We are learning from them. So, like our state director just mentioned, this is like the kernel of our meeting. This conference that's only today and tomorrow, this is like the high point of it. So let's give attention. The second paper is coming now, and after that, the third paper. So I will allow you to take your notes on these 3 papers on conflict resolution and ask your question all at once so that we can take all 3 papers and then ask for clarity. So you don't ask questions from what they are going to teach next. So the next person to present a paper still on conflict resolution, but of course I believe it's on the continuation, is Mrs. Juliet Emilue. Let's put hands together for her. She makes the podium. Please, okay, you are eating, I understand. We appreciate you, man. We love you and we are grateful you are here today. Thank you. The slide is there, right?
Good afternoon, everyone. Yes. So much has been said about peace. Peace. And that's why we're here today. as peace advocates. My name is Julius, and I'm a mediator. Now, I want us to look at the topic for today. Without wasting time, I beg to stand on all protocols that has already been observed. So, before there is peace, there would have been conflict. All right. So, I'm a mediator at the Multi-Door Court House, the head of mediations at Warri Registry. What we do generally is to help parties achieve justice through ADR. And what is ADR? Alternative Dispute Resolution, which is alternative to using the courts as a system to achieving justice, as a system to achieving development and peaceful coexistence. So if you have the option of going to the Multi-Door Court House, you may find out that it will be a waste of time going to the court in the first place. So I'm here today to enlighten us about the uses of ADR in our judicial system. And that's why our office is attached to the court so that there is easy access. So nobody says, it's far. You come to the court, there is an option. There are doors. That's why we are called the multi-door. The door of mediation, the door of early neutral evaluation. We also have the door of conciliation and negotiation, as well as arbitration. These are the mechanisms to settling disputes out of court as an alternative to litigation. Every one of us knows here how Herculean it is a task to go to the courts. If you've not experienced it before, I pray you don't experience it. Because being in court is like being in police custody. You are not free. Every day your lawyer calls you and tells you there is an application that he must respond to. He tells on you as a person, he tells on you financially. And somehow you secretly wish that there was an alternative. But don't worry, we are here today to let you know that even as world peacekeepers and advocates, you can make use of these ADR doors. And it's simple and less expensive. Those are part of the benefits. It means that with the congestion of courts, we can still find justice. A poor man can still get justice. This time around by dialoguing, by talking, by communication. Like I said before, so much has been said about peace. Peace is the presence of justice. Peace is the presence of the rule of law. Peace is the absence of conflict. But we know that conflict, like we've all agreed here today, is inevitable. It's there in our homes. It's there between husband and wife. It's there in the community, the nation. ASU and the federal government, they're on their own, fighting day and night. Even in Warri here, it's not alien to us. The Alaja community and the OM, they are at it. But can somebody tell them about peace? That's why I'm here today. I'll quickly, because time is not on our side, I'll quickly go through the slides and then speak to us when necessary. So, like we said, conflicts and disputes are all normal way of life. it will be very strange if there is no conflict. But then when they arise, when they come to us, or when we meet them at any levels, what do? We run to safety, and that safety can be found here at the multi-door courthouse. I'm going to be emphasizing on that, but that's where I work, and that's where we'll be making a whole lot of difference, making peace, making people hug, people who wouldn't talk to each other before because of conflict. At the end of the day, it gives me joy to see them hug each other. And then many of them say, Madam, thank you so much. I didn't know we could settle this out of court. So, now that we've been introduced to mediation, I want us to know that even this mediation we're talking about has a historical overview. Let's see about that. A historical overview tells us that even before the judicial system, the English people introduced the courts to us, there was a way that our parents, our forefathers used to settle disputes. I grew up to notice that in a family, hardly people go to court in my place. And that's why up till today, there's no high court in my place. Because when there is dispute, it is settled within the family domain, within the community domain, and then it doesn't have to escalate. But these days, people have taken to the courts, and that's why you see that justice is far. Justice now is for the rich. My elder here was talking about his family matter, and then in his own view, that was not justice. But what if that matter had come to the multi-door? What if we sat down as parties and discussed and talked about it and then shift grounds? There will be a win-win at the end of the day. So, what we have here as mediation is something that has been practiced in Nigeria a long time ago by our forefathers. But now, it's only been made known. And I'll tell us the difference at the end of the day. Because even then, when our forefathers mediated upon matters in family court and the community square, the only thing lacking was a binding agreement, like a written agreement. And that's what we offer. At the multi-door, there is the opportunity for your agreement to become binding. You will see that as we go on. So with this, I welcome you all to this presentation. What is mediation? Somebody will ask. Some may have not heard it before. To mediate is from the Latin word mediatus. Okay, mediatus. That's why I said that. So now, mediatus means to be in the middle. To be in the middle. Let's see. No. What is mediation? Yes. What is mediation? There's somebody in the middle. Okay. So, mediatus means to be in the middle of two people who are disputing parties. And what is that man in the middle going to do? He's going to stand in the gap of breaking communication. He's going to stand as a facilitator. So, in other words, mediation is defined as a form of assisted negotiation where a mediator can bridge the communication gap between the parties, thereby facilitating a settlement. Mediation is also a private, voluntary, and informal process where a party selected neutral, assist the disputants to reach a mutually accepted agreement. So, we're looking at the characteristics of mediation. 1, it involves 2 people or more parties who are in dispute over some issues. It also involves entirely voluntary for non-litigious dispute. What that means is that the voluntary characteristics of mediation has to do with matters that are non-litigious. Matters that are non-litigious are those matters that do not have to go to court. What are such matters? Like matters between a husband and a wife, where divorce is not an issue. Matters between family, relative, blood relatives, they're not supposed to go to court. They're supposed to go for ADR, alternative dispute resolution. So, the other characteristics is that it is a non-coercive process, in that the mediator does not decide the outcome of the settlement. The mediator stands as a neutral third party. Okay. So, one of the characteristics is, I'll just rush through this, is that the mediator encourages the parties to explore alternative possibilities or options in settling the dispute. You will agree with me that all of these characteristics are not present in the litigation that goes on in court. And the court system is very formal. A party is not given the opportunity to even speak. It's your lawyer who speaks for you. And many of the times when you tell the lawyer, this is my case, he looks at it and says, maybe if I do it this way, I'll do it this way. Apologies to my colleagues who are here. If I do it this way and do it this way, it might just make the matter, elongate. And then money will be coming in. Because that's where he eats. One of the speakers said earlier that if there's no conflict, lawyers will not eat. That's the truth. So, no lawyer wants your matter to end quickly. They keep collecting the money. Because that's where we eat. There's a friend of mine who has a poster on his car and he says, trouble on my work. Because I'm a lawyer. Oh, so without trouble, a lawyer will not eat. So at the end of the day, we discover that going to the mediator or the mediation process is more effective because of all these underlisted characteristics of the process. Now let's go to the benefits of mediation. The benefits of mediation, 1, it saves time. I'll give us an example. You go to the normal regular court and then your matter is filed, and then it takes like 3 months before the other party is served of the processes. Because there are also issues with service of court processes. At the end of the day, somebody may evade service, and then what you have next is substituted service, which will come by way of an application, an ex parte application to the court to grant you as a leave to serve the document at the last known address of the defendant. Now, your matter has not already begun. We are just talking about service. And it has taken 3 months. So at the end of the day, when this matter is ripe for trial, it takes a longer time. There may be interlocutory applications that will say, this judge doesn't have the jurisdiction to entertain this matter. The court lacks the jurisdiction. And you, who is the litigant, will be like, That's not what I asked my lawyer to do. But your money is going. So, but when you come to the multi-door, you come through the ADR, you come through mediation, you save yourself some time, you save yourself some cost. Delta State has been benevolent enough to make it cheap to approach the multi-door. All you need to do is come in. If you are coming through the court-referred cases, it means that somebody may have suggested to His Lordship to say, please, my Lord, can I settle this matter out of court? And many times the judges jumps at it because it is rare, especially in this part of Nigeria, to say, I want to settle my case out of court. So, you come to the multi-door by a court referral. There's still another means by which you come to the multi-door. We call that the walk-in. The walk-in means literally to walk in through the doors of the multi-door. To say, I am tired of going to court. I need to settle my matter using the multi-door. So it saves you time and it saves you cost. Yes. The third benefit of mediation is that the parties decide their own outcome. More like writing your own judgment. It's a privilege to be the one to write your own judgment. Because even in court, a winner is not always a winner. That's from experience. Sometimes even the judgment of court confuses you the most, that you are not sure whether you are actually a winner or a loser. And then if you need to interpret that judgment of the court, you have to make an appeal, costing yourself extra money in order to get an interpretation to the judgment of court. If you've not been to court, you may not understand where I'm coming from. So, at the mediation, it's like writing your judgment by yourself. Now, number 4 of the benefit of mediation is that it mends broken relationship. That's the sweetest part of it. Every one of us here, peace advocates, understand how it is to see brothers dwell again together in harmony after a long time of conflict. It's a joy that is unspeakable, even as family members, as community leaders, as elders that we are. When should I just move to this mediation and then set myself free? And the other person will say, my matter is almost at the end. I'm here to tell you today that there is no specific time for peace to be achieved. Peace can be achieved even before the crisis becomes conflict. And even early in the conflict, you can also seek for mediation as a means to settling it. The legal framework of mediation in Delta State. Mediation practice in Nigeria is subject to both state and federal legislations. But in Nigeria, we have all these laws backing us up. We're not just doing it on our own. We have the laws backing us up. We have the Delta State Multi-Door Courthouse Law of 2012. And then we have the Delta State Multi-Door Courthouse Practice Directions on Mediation. We also have the Institute of Chartered Mediators and Conciliators Mediation Procedure Rules. And then we also apply the general rules of contract where there was already an agreement. So we go to the next slide. Who is a mediator? I am a mediator, but I want to tell you about me. I want to tell you about what I do and how I do what I do. a mediator is a neutral third party who assists disputing parties to arrive at an amicable settlement. Neutral, underline the word neutral. I tell people when they come to my office, I do not have an interest in your case. I do not have a personal interest in your outcome. So there's nothing that stops me from being truthful. There's nothing that stops me from being impartial. Who is a mediator? He's a facilitator. He facilitates the process. Without a mediator, there will be no mediation, because it was lack of communication in the first place that has brought this crisis this far. So you need that neutral third party to wade into the matter, build a bridge, and overcome the lack of communication. Now you will ask me, are there any legal requirements on who can serve as a mediator? I will be fast with this now. By law, there is no legal requirement of who can be a mediator. But then, you and I know that when matters go to court, there is no trivial matter, there is no small matter. Every matter is as important as it is to the owner. So, you have to be trained as a mediator to handle sensitive matters. You have to be disciplined. If you are not a disciplined and a trained professional mediator, I bet you it's going to be difficult. So, I have already talked about the roles of the mediator while I was talking about the mediation. So, I'll just go to the stages of mediation. There are about 7 stages of mediation, but I'll just wrap it all up, because time is far spent. First of all, you have a pre-mediation session. That pre-mediation session is a session where you get to know the parties. You don't know them before. You get to know them, you get to meet them. A whole lot of skill is applied in getting to know the parties, getting to get good rapport with them, get an understanding of what their interests are, what their issues are, what their concerns are. It's at that meeting, like we all know, first impression matters. You come to my office for the first time for peace to reign. Once that impression is created in you as a mediator, to participate in the mediation, what does that entail? That even if it's a family land that is the issue, a child of 15, 16, 17 cannot come to represent the family, even in the mediation. Why? Because the legal age for legal representation is 18 years and above. And even at that, when it has to do with land, you talk about the elders, who we call the principal members of the community or the family. So it's at the pre-mediation session we'll have the opportunity to examine all of this. Then you fix a date for the mediation proper. Now that a date has been fixed, mediation commences. One, you have a very important protocol that must be observed. Somebody who is not into mediation will not understand until you are there. And that is the sitting position. a sitting position has to be planned in a way that depicts the impartiality of the mediator. Please, the slide. It's very important because conflict has created a gap between the parties. Some people, when they come into my office for the first time, they don't want to sit close to each other. That's because conflict has created a barrier, a distance. You can smell it. They don't want to sit even in the same office. And then I have to do a lot to convince them to have your seat, sir. Have your seat, man. And then you look at them with, why I won't sit down near this man that has taken me to court. So you see that sitting arrangement matters. Now I'm going to be showing us a little slide to depict how convenient this sitting position, let's see the other one, this sitting position, this sitting position. How about this? How about this? That's to tell us that sitting positions can create further conflict. There's how you will sit in a mediation session, and it will give an opportunity for slaps to begin to rain. Slaps will be rain up and down. So, we avoid all these situations when we are dealing with people because they are angry. So as peace advocates, these are very important points that you should take note of. You don't just gather people together and say, yes, I want to make peace. Because a whole lot of things means a whole lot to them. As minute as sitting down, somebody will even say, I can't even go there and sit with him because he may have rubbed something on the chair. So it takes a lot for a mediator to be able to bring people down as small as sitting so that mediation commences. And then you should protect yourself as the mediator. Make slap no near you. This is my fine face too. If I collect slap 1 time, 2 times, I'm sure the face will shift. So sitting protocol is very important to a mediator and a mediation session. I'll just rush through. The paper is available to everyone. I hope so. Yes. Yes, it's packed full, so it's good for us to go through it when we have the time to. So the next stage will be the mediator's opening statement. That's stage 3. At this point, the mediator opens his statement to set the stage for the process. What he does basically is to introduce himself and his qualifications, because many people come to the office, especially advanced old men, and then they look at me from my seat. See, so this judge don't see me finish, eh? See, small pikin, I carry me give, make it settle my matter. But you know, I always tell them that age doesn't make a difference when it comes to wisdom. So, they come in, and within the next few minutes, I see that their countenance has changed. Why? Because I've been able to create another impression, different from what age would have offered me. Some people, especially from this our side of Nigeria, chiefs and every one of them, they come to me and they say, this matter has gone to the King's Palace, this matter has gone to the councillors in council, and it has not been resolved. I tell them one thing. At the King's Council, there are people that you have relationship with that may not be able to tell the truth where the truth is glaring. And those are the things that hinges the failure of mediation when it has to do with community and elders in council. So, at that opening statement, it creates the aura of confidence in the process. As a mediator, you'll be able to create that impression that in this matter, I am not going to be biased. I'll let you decide. I will only assist you to reach that negotiable agreement that will satisfy everybody. The next stage will be the party's opening statement. Slide, please. The party's opening statement. That's stage 4. This is a stage that allows the parties to fully communicate their understanding of the problem. Sometimes, even when they are in court, they do not even understand the extent of their problem. And because once you tell a lawyer, file this matter for me, sometimes the parties don't even have access to the files anymore. They don't know what their lawyer is filing. You file this application, you are not aware. You file the other application, you are not aware. The other party serves, you don't know what they've served. But when you come to the court, through the multi-door, everything is laid bare. The parties will tell the lawyers, it's the party that has the say here. It's a party-oriented process. So, they must be the ones to address themselves. In the process of the parties addressing their issues by themselves, not by the lawyer's understanding of the issue, so many things are laid to bear. And before you know it, solutions begin to emanate. At the stage 4, where the parties have opened their statements, the mediator brings all the concerns to light. Because even while they are talking, they do not know that they are laying the issues bare to the mediator. So your expertise is put to use at this stage because one, the mediator must be intelligent to be able to know what issues are really at stake. I've had to mediate over a matter where the old man says, if only this boy that I brought from the village can apologize, I withdraw the matter. So in essence, what is actually bringing these people to this extent of being in court? Pride on the part of the young man to apologize to the old man. And he says, I have money, I can take it to court. So when he said that, as a mediator, I took advantage of it. Because it was said in a private session. And when we were at the joint session, I told the man, Papa, you said something. Would you agree for this young man to do the needful? Because I also spoke to him during his own caucus. I said, Papa only needs you to apologize. And then he took the initiative, did the right thing, and that was the end of that matter. Although the initial thing that took them to court was based on failed contracts, but at the end of the day, a little apology settled it all. That's what peace advocates do. I'll go to the next stage, and that's stage 5, the joint exploratory discussion. Yes. After the summaries have been made, after the lawyer, the mediator has been able to put down all of the concerns of the parties and their interests, he puts them down. He rephrases to the parties and says, did you say this, did you say that? And then the party affirms to say, yes, that's what I said is the issue. You see that the next stage is simpler. Because at this stage, all the parties have come to a full comprehension of all their demands and their expectations of each other. The mediator cannot do without a private caucus. What's a private caucus? A caucus, like we always say, inner caucus. It's a meeting that meets the mind. So it's a meeting where the mediator calls on the parties in private and talks to them, because it's not everything they want to disclose in the presence of their enemy. So you must have the patience to go through the private caucus. It may be once, it may be twice, it may be 3 times, just to arrive at a solution. And during that private caucus, we do what we call reality check. Reality check. Let me give you an example. A man and a wife were having a divorce suit, so that we do not interfere. With so much. This is you, and this is you. And at the end of the day, they don't care if it's the children that are going to suffer it. All he knows is he wants to rip this woman off the custody of the child. During caucus, I asked him a very good question. How old is your daughter, sir? And he said, she's about 8. She's about 8, yes. I said, okay. So, has she started seeing her monthly period? He said, no. So I asked, if you are in custody of this girl, don't you think it would have been better that she's with her mother when she sees her period for the first time? Like it has never occurred to him before that the girl will see her period and he will be lost as to what to say. He said, I didn't think of it. Okay, she can have the custody, And that settled that aspect of it. You know, the stage where we bring in private caucus is a stage to put reality questions straight to the people. And then when they realize, what have I been doing? Let peace reign. Today, those people are friends, even though they've been divorced by the court. So the next stage I'll go to is negotiation. But I don't want to dwell on it because my colleague will dwell extensively on that. But I just want to tell us that there's a stage called negotiation in mediation process. That's the stage where you negotiate like normal. You shift backward, you go forward, until a middle ground is established. That's the stage. So, I'll go to the closure. That's stage 7. So after the negotiations ends, the mediator seeks to finalize the whole process. This process is very important. The mediator, at this point, to be a lawyer as a mediator is very, very handy, because drafting an agreement, a settlement agreement, is quite different from settling a matter. If you successfully settle a matter and you draft an agreement, a settlement agreement that does not convey the interest of all the parties, you have done nothing. If you ask me why, I'll tell you this. So many of us here, we're all learned in our own field, but not in the field of drafting an agreement that will not put you in trouble tomorrow. It's only a lawyer, I beg to say that can draft a perfect agreement that will not create conflict tomorrow. That's why this stage is very important. And I wish that we will have another opportunity to be like this, so that that stage will also be put to bear for the peace advocates. So that at the end of the day, when you are able to attain all that the mediator does, you should be able to draft a valid agreement. I hope that happens one day. So now we ask, what is a mediation settlement agreement? It's not just an ordinary agreement. It's a legal document that comes at the end of the mediation process. It outlines the terms and the conditions agreed to by the parties. And it's done with the help of the mediator. Drafting in law school is a course on its own. We call it legal drafting. So meaning that it's not something that anybody can just dabble into. So, a mediation settlement agreement has to be drafted accurately without errors that may bring further conflict. And somebody may ask me, must the settlement agreement be in writing to be enforceable? No. It doesn't have to be in writing. But to be safe, to be on the safe side, it's better that the agreement is written down. And that is what I said earlier when I started. I said, mediation is something that has been in existence with our forefathers. But the only difference is that they hardly put down those agreements reached in writing. And when you have a matter that has to do with land, and then all the witnesses to that agreement are dead, what do you do? So, you come to the multi-door, and then we'll put it down in writing. And then, it doesn't stop there. Especially if it is a court-referred matter, after the parties have signed and the mediator have signed, the judge appends his signature. You know what that means? That means that that agreement carries the weight of the judgment of the court. Yes. So we do not just create an agreement and then people sign and go. It carries the weight of the judge. Because in law we call it consent judgment. A judgment that was given by free will. And there's no how anybody is going to deny that kind of a judgment. So say, no, I didn't sign it. No, you signed it. It's not a consent judgment. And it can only be appealed at the Court of Appeal to say, I didn't sign that. I did it out of duress. And it's going to be hard to prove. Because at the mediation, we have agreements that parties signed to authenticate their coming to the mediation. You sign that you are submitting yourself to mediation. All right. Now that we know that coming to the mediation helps us get a binding and enforceable settlement agreement. All right. Should I just leave? Oh, okay. But I hope we are all enjoying and learning something. I wish we had the time, you know. Thank you, sir. So, I will just go straight to some of the challenges that are facing mediation in Nigeria. And that's, yes, mediation, the challenges. We have the low level of public awareness. People are not aware. As educated as many of us are, we don't even know that there's something like ADR. We don't even know that there's something like as simple as mediation. So I'm happy that a lot of us are being educated today. You tell one person to tell the other that, man, justice is simpler now. Yes. So the low level of public awareness is a challenge to us. And what do? We enlighten people on seminars like this, advocacy seminars like this. Then many people see it as inferior to litigation because people see that when you go to litigation, you have money to spend. The third is the voluntariness of the mediation makes it very hard for people to actually give their best. We tell you it's a relaxed atmosphere. Some people take advantage of it, and they misuse that advantage. We also have the resistance to mediation. We have challenges from our colleagues, lawyers. Serious one, we're battling seriously with it. All we do is go to MBA seminars, present talk shows like this, enlighten them on, the advantages. That it doesn't stop anything. It just doesn't stop you from charging your accurate legal fee. But it's taking us a whole lot. Then we have the lack of mediation law in some states. Lucky enough, Delta State has the laws that back us up. So we're not just functioning from the backyard. We have the backing of the law. So I won't be able to go through all of, but then I want to leave us with this. That peacemaking involves the use of cooperative, constructive processes, just like this. And that peace cannot be kept by force. You don't force peace on people. Peace is achieved only by understanding. Thank you so much.
Thank you very much. A wonderful piece indeed. Please let's applaud her some more. Wow. Speaking quietly, softly, but she has some level of tenacity. I'm telling you, standing for that long and speaking like that. I'm sure you are enjoying yourselves, and I'm sure you are learning. And to think of it that you are lawyers, madam, are you a barrister? Whoa, so you are a barrister and you chose the way that may be quote and unquote less rewarding for you and more rewarding for the society. Right? So you are more or less like us that have volunteered to keep pace. Thank you very much for this endeavor. God bless you. We hope and pray that your work will come to light so that people will embrace this more. We have the alternative, then why go through the war? I believe that our brother here, you're already thinking, if you had gone through this alternative means, maybe you would have gotten real justice. Because one of the problems of the world is even distribution of justice. We have too many miscarriage of justice because of the rhetorics of lawyers that are intelligent. Like you see what happened in our brother's case. They are intelligent, they speak very well before you know, armed robbers will go scot-free and innocent people will go to jail. So thank God for such introduction, and we pray and hope that he gets the needed acceptance in the society. Please jot your questions. We have one last paper to go. And then if you have questions, we're going to take 6 questions. 3 for the first one, 3 for this one, and 3 for the next one. We're taking just 6 questions after this paper. Okay, let's wait until then. Let's not share what have not been gotten.
Ladies and gentlemen, we just thank all of you for the patience and listen attentively to these wonderful lectures. We are very grateful and we appreciate all of you. We know we have one speaker, but before then, The international spokesperson just arrived from Abuja, so and entered this hall. I think my eyes were not deceiving me.
No, you're right.
Okay, let's, the thing is very far.
Yeah.
So let's make welcome the international spokesperson of this organization, the engine house of this organization. It's not any other person than Chief Dr. Emmanuel Nkweke. Okay, let's put our hand. He's coming. Like I said, my eye didn't deceive you. For some time, we have been running up and down for a lot of activities. We will only take 2 questions if necessary, so that the last speaker will do justice. Okay, we want to put that together. This one is mediation, and that one is negotiation. Okay. All right. I understand. Okay. All right. Okay. So while he's coming, let's go over for the next lecture.
Thank you very much, Professor Director. I'm glad to have our guy mentor in the house. He said his flight was delayed and he still decided to make it here. Tomorrow, we're going to hear a lot from him. We also have Ambassador Dr. Tika Okilolo to present the paper tomorrow to us too on mental health management. So please, we have a lot. This conference is overloaded for us. And I hope you will come tomorrow. Please let's ensure to be here for this program tomorrow. And all these conference materials, all this speech that's presented here, they are available. They are very, very available. But we are going to make it only accessible to those that have completely registered for this conference. So those that fill form and didn't pay will not get it. For those that fill form and paid, they are the only ones that will get the material. And I'm very sure you understand what I just said. So let's go on to the last paper for the day as our boss is getting settled. The third paper for today will be presented by Mrs. Ogene Runa Robinson. Let's applaud her. Please, ma'am, the other colleagues are taking your time, so please be generous to us. Be generous, sorry for us, just manage 20 minutes. Thank you, ma'am.
Please just lend me your ears for some time. I won't bore you with repetition. We have known what conflict is all about. They've defined conflict and resolution. So the theme is a conflict resolution, a major tool to achieve national unity, peace, security, and development. So how do we resolve conflicts that will bring about the theme of this year's conference? We can all could resolve our conflict via alternative dispute resolution. I am from Delta State Multi-Dog Courthouse. I work in Ughelli Registry. ADRO refers to a range of processes designed to aid parties to resolve their issues. We have different ways of resolving disputes outside the formal judicial proceeding. There is a high degree of party control in ADRO over the way the dispute is resolved because of its private nature, and also the disputing parties create their own process and draft their own agreement. It's the parties that bring out the agreement, the terms, the agreeable terms during their negotiation. So as a peace ambassador and an advocate, you can act as a mediator or a negotiator or a conciliator. So at the Delta State Multi-Dog Courthouse, we resolve dispute through the following alternative dispute resolution mechanism. mediation, conciliation, negotiation, arbitration, and early neutral evaluation. I just want to make a quick definition of the process, apart from mediation, because my colleague dwells on mediation. So conciliation is a process whereby the parties to a dispute use a conciliator who meets with the party both separately and together in an attempt to resolve their differences. Like as I said, you can act as a peace advocate, you can act as a conciliator to resolve disputes between members or between your community members. You can go to them either separately to say, this thing that is happening, why can't we do it this way? You suggest to them. Or you can call both of them together to resolve their dispute. Then negotiation is a process which allows the disputants to meet in order to settle their disputes. The main advantage of this form of dispute settlement is that it allows the parties themselves to control the process and the solution. Negotiation. You negotiate, you meet with the person. This thing that is happening, how do we go about it? They give a way forward. Or and at the end of the hearing, renders a binding and enforceable award. Arbitration is a semi-court. Semi-court, where an arbitrator is being appointed to arbitrate over an issue. So the parties submit their statement of claim, statement of defense, their documents, their evidence, all of that before the arbitrator. Arbitrator will look at it and give an award. So that arbitration is semi-court. The early neutral evaluation is a process in which an experienced attorney, retired judge, or a dispute resolution officer evaluate the relative strength and weakness of the positions advanced by the parties, the probable outcome of a trial, and advises the party accordingly. This one, an experienced person, either a judge, a retired, or a dispute resolution officer like we, that is working at the Delta State Multi-Door Courthouse, we look at your case and suggest to you the probable outcome of this matter, the strength and the weakness. So, and I will advise you to use alternative means to settle the matter. I gave the swift definition of ADR options or doors through which parties can resolve their dispute. The reason why it is called multi-door is that it is appropriate to apply in resolving their issues. You look at the doors that is open at ADR, multi-door courthouse. You have the doors of mediation, you have the doors of negotiation, you have the doors of conciliation, whichever that you want. The means that will resolve your matter according to your desire. So, it is the responsibility of a practicing lawyer to expose clients to an alternative methods of dispute resolution and explore with them the most appropriate mechanism in the resolution of matters brought before him or her. The lawyer 2012, I need to say, section 18, section 2 of that law stated that it said counsel has a duty, if there is a lawyer among you, has a duty to expose clients to alternative method of dispute resolution and explore with them the most appropriate mechanism in the resolution of matters brought before them. It is a duty of a lawyer. Unfortunately, practicing lawyers who believe that ADR is a waste of time and a drop of revenue. Some of our colleagues think that ADR is a drop of revenue because it doesn't take time. At ADR, something that will take you in court for 5 years at the first instance court, before you go to Court of Appeal or Supreme Court, within a month or 3 months at most, you are done. So based on that, some of our colleagues, a lawyer, we think that it's a drop of revenue. So for that, they don't expose the client, they don't expose the parties, the disputants to an ADRO option. So well, thank God for those of us, the peace advocates and ambassadors that are here today, to go and spread the good news and introduce to others alternative ways of resolving disputes or conflict in order to achieve the theme of this year conference. As a peace ambassador or advocate, you have a duty to preach peace and practice it. Not only preaching it, you have to practice it. You have to be a calm person, because before you can tell somebody to do something, that means you have been doing it as well. You cannot tell the person to pursue peace when you are a troublemaker. Thank you, madam. So as a peace ambassador, you have to practice it in order for you to preach it to others. So the functions of DSMDC, like the functions of Delta State Multi-Law Court are provided for in section 5 of the DSMDC law 2012. But I won't bore us with that. When you have the paper, you see it, it's stated there. The beauty of ADRO is that it is a party-driven process. So the disputants control the process and generate what they consider to be the terms of settlement that satisfy their mutual and corresponding needs and interests. They themselves talk out the terms the way they want it to be. This is how I want it. Okay, let me shift a little here, a little there. That is the beauty of ADRO. And at the end of the day, you will be satisfied with the outcome of the process. You are at liberty to use any of our registries to register your conflict or dispute. As a peace ambassador, for instance, you don't have a venue to negotiate or to mediate or to conciliate in a matter that you want to resolve in your community or in your family or maybe election matter, whatever. You can as well use our office. You can as well use our multi-door courthouse as a venue. We will give you, oblige you with our venue to resolve your dispute. So apart from Asaba, which is the headquarters, we have DSMDC, that is Delta State. When I say DSMDC, means Delta State Multi-Door Courthouse. I don't want to mention, state it all the time. Registry. We have a registry in Warri, we have in Efru, we have in Saple, we have in Ugeli, we have in Ozoro and Agbo. I am in Ugeli. Choose the registry that is closer to you. Anyone that is closer to you to save money. The Delta State Multi-Door Courthouse jurisdiction is unlimited because it is the disputing parties that gives us jurisdiction to handle their matter for an amicable settlement. The jurisdiction is unlimited, both civil and criminal, but the court will not refer criminal matters to the multi-door. And state council have never encouraged it because statutorily, because it is an offense against the states and not the people. Criminal matters are offense against the state, not the people. However, it is becoming almost a regular occurrence for victims and perpetrators of minor crimes and misdemeanors to explore ADRO as a means of resolution. Like cases like rape, for instance. The deed has been done. Though I'm not encouraging anybody to go and rape anyone anyway. But the harm has been done. And for you to prove rape is difficult. Proving rape is very difficult. So based on that, the harm has been done, the person has been defied. So what do we do? After filing in court, because it's a criminal matter, if the person, the accuser or the accused now felt that what I've done is wrong, I want settlement out of court. Because even if it didn't settle, if the ingredients of that offense is not proved, the person will not be convicted. So you have wasted years in trying to find justice. So most of the criminal matters is good we settle because court will not refer it. But you as a person you can approach the victim or the family to resolve the issue. The victim will get restitution, will be compensated, and the accused person will be made responsible for his action. The most common mechanism of resolving dispute via ADRO is mediation, conciliation, and negotiation. So my colleague dwells on mediation. I would love to dwell on conciliation and negotiation interchangeably as a means or doors of resolving disputes or conflict that will bring about unity, peace, development in the society. Conciliation is a consensual process whereby parties submit to a third party neutral who has no interest or stake in the subject matter of the dispute to facilitate resolution of their dispute on mutual agreed terms. It helps the disputant to generate a mutually acceptable outcome. The process is voluntary, confidential. So you are sure that the process is private and is voluntary. And before you come to multi-door, or before you try to resolve your issue, make sure that you are ready to settle. Because there are some parties already in court, they will refer them to multi-door. They are not ready to settle. They've made up their mind. They will just, okay, court have referred us, let's just go there. They will come there, they will make up their mind, they will give you their release. Being sought in the court, they will still say, this is what I want. That means you are not ready to resolve your issue via ADRO. So if you are ready to resolve your issue, you must make sure you shift ground. So the process is voluntary, confidential, and the conciliator and the negotiator does not render a decision, but helps the disputant to generate a mutually acceptable outcome. So as a negotiator or a conciliator, know that you are not there to make decisions. Peace ambassador and advocates, please, if you are acting as a negotiator or a conciliator or a mediator, make sure that you don't take decision. You don't stand on one side. You must be neutral. You can suggest to them if you want. That is the job of a conciliator. You suggest, but don't take decision. So I have a case, we have, like at the multi-door courthouse in Ughelli Registry, we have resolved so many cases between same families, different families, community crisis, etc. In the Delta State multi-door courthouse, Ughelli Registry, that brought about peace, unity, development, and growth in families and communities, for instance. I have a case scenario, because we have to be practical sometimes. How does this thing happen? So that it will not be as if we are just talking for talking's sake. We have resolved contentious matters in our registry. So, and I know the mode that we use to resolve our contentious cases, the peace ambassador can as well use that kind of technique and also resolve contentious cases in your community and your family. The case scenario on conciliation and negotiation. The government acquired a land from a set of landowners, and he told them that we are going to build a low-cost housing estate. So, with the intention of developing, building, and providing low-cost housing scheme for the people, for them to enjoy. So, based on that, the set of landowners now submitted their land to the government to build a low-cost house estate. But I believe me or you, deceit. At the end of the day, they gave it to a private developer. The private developer started selling the land to others, to people that is not even from that community, making money. So the set of the landowner that submitted that land felt grieved. They were grieved and they sued the government, the developer, the AG, Commissioner for Justice, Land and Survey. So they sued them to court. When they sue them to court, the judge look at it that it's a community matter. That is a community matter. So based on that, they brought it to the multi-door courthouse, and we look at it. We now find out that there are other. The first thing we did at the court registry was to give all parties the opportunity to give their own narrative, which are usually statement of issues filed. We acknowledge that the position and narrative, which is the story each party brings to negotiation table. The next stage is how do we resolve this issue that will be acceptable to the disputants. In the course of conciliation and negotiation, we discovered that the executive of the committee had been benefiting from the developer, that is the company, by getting all the benefits. To wit, employment opportunities, supply of contracts, and commission derived from patriots of sand entering the estate. So because the community, the executive have been benefiting, they did not bother to sue the developers. So when this set of landowners now sued, they were now angry. So during the estate to the landowners, to the disputants, we suggested in order to resolve the issues. So we suggested that part of the undeveloped land be given to the landowners. Then we also suggested that the landowners and the community led by the executive should supply labor, contractors, and commission for each strip of sand to the estate to be shared by both parties, that is the landowner and the community. The above suggestion was taken by some of the landowners. One of the landowners insisted that no, that the cost of this acquisition and no compensation cost his family dearly, and his father died because of that. Based on that, he does not need compensation. He wants his land back. So it took us time for us to be able to convince that man to make sure that he see the point of view of the developer and the other parties involved in this dispute. At the end of the day, the executive, not the community now, the executive now said, for us to have a peaceful settlement, we have to consider their own personal interests. Greed has come to play. So, but to God be the glory, we're able to settle it. The developer agreed to accept, to give part of the land and all that, and we settle. All the parties' interests were well represented.
Shall we all rise up on our feet?
I know that any time from now we'll do our closing prayer, but I'm looking at the number of women here. We need to expedite some of our things, because on the high table here, only so one woman here. So I'm happy. I came with my wife, she's also here, so I came with my wife. For those who do not come with their wife, please plan to come with the wife tomorrow. Thank you very much, and God bless you.
Okay. By the power conferred on me as the International Director of this organization, I hereby declare today's conference closed in the name of the Father, and of the Son, and of the Holy Spirit. Amen. God bless all of you, and we see tomorrow.
You